Has your spouse controlled the money, controlled the spending, controlled the paying the bills, controlled bank accounts, controlled buying or selling assets? You notice the word I'm using consistently? Controlled, manipulated, abused, taken advantage of. If so, this episode is for you. Let's talk about what that looks like and what you can do. Stay tuned.
Welcome to Self-Represented in Family Court, the only podcast you need if you're feeling lost, stuck, or overwhelmed in family court. At Self-Represented, we don't waste time discussing the law like all the other podcasts. We focus on what really matters in your divorce or custody case. That's strategy. With your host, Tracey Bee, former family law attorney turned pro se family court strategist.
Something I've noticed in my 25 years in family law is that when someone tells me their marriage involved financial abuse or financial control or financial manipulation, the controlling spouses, they usually all play from the same playbook. And they don't snap back into shape or get themselves in order just because they know they're going to court or the divorce proceeding has started. Actually, no. Their antics, their behaviors, they usually get worse. Unfortunately, though, those same dynamics that existed during the marriage play out in a divorce, making the divorce process more expensive, more stressful, and more time-consuming. So let's talk about some of those scenarios they typically do, what that looks like. Let me give you some examples. The joint account suddenly has less money than it usually has. It used to have around 15, 20, 25,000. All of a sudden, it's down to $2, maybe even $300. Your spouse starts saying things like, "We can't afford that anymore," even though they've been paying the same bills for years. Now, all of a sudden, what they've been used to, including in the budget, all of a sudden becomes a luxury, something you can live without. How about this one? Household bills stop getting paid, or they're paid late. You're getting shut-off notices, and you've never gotten shut-off notices. And they used to pay them on time before. How about this one? They're moving money between accounts that you don't even recognize. Or they're opening accounts in their names only, when prior you had joint accounts with both your names on it, or at least you had access. How about this one? When you start to ask questions about money, they start saying, "Oh, you don't need to know that. I always manage the money and I always will. I'll continue to do that." This is a good one. They suddenly claim their income dropped. Sometimes they even go as far as saying that they lost income completely. They're out of work. They don't get bonuses anymore. They lowered their revenue, sales, commissions, you name it, right? Let me know if any of this sounds familiar to you. How about this one? They also start suggesting things like, "You know what? We're going to go through divorce. We need to settle things, keep the lawyers away, keep money down, keep costs down." That is something I hear all the time, and I tell everyone not to fall for it. Yes, it's okay to want to save money, to want to resolve the divorce quicker, to keep the stress down, to keep the peace, but you should not rush into anything, especially if you're coming out of a financially abusive marriage or relationship. But it also happens in situations where the working spouse stops contributing. Now we're talking about the divorce. The divorce is actually pending. and you're in the marital home, or you're, in a position where you still have to maintain not cost of living, you still have to maintain food and shelter for your children, and they used to provide all that. And whether they're in the home or not, they don't want to do that. They don't want to help take care of your children, your mutual children. They don't want to help maintain the cost of the house. They don't want to do any of that. Any of these sound familiar to you? How about you are in a position where you finally come to the realization and you want the court to be made aware of this? Should you? Let's talk about that. Should the courts be made aware of these financially manipulative, abusive, controlling antics and behaviors of the other party, your spouse? Let's start with number one. Family court is not really a place that is going to get itself involved in any sort of financial controlling, imbalance, power pushing scenarios. Family court is not going to intercept itself in scenarios like that. They're not going to involve themselves in the way that you think anyway. So let's talk about you actually presenting this issue to your court, your judge. First of all, what does that look like? Especially since I just told you that they're really not going to take the initiative or independently penalize, even explore the existence of financial mismanagement, manipulation, control, or abuse. So, what does it look like for you? You definitely want to tailor the issue of financial abuse with respect to specific claims you're making. You don't want to go to court and instantly tell the judge or wave this red flag, hey, he or she abused me, he or she controlled the money to my disadvantage, and they're doing it now, they're continuing that level of behavior, and I need you to step in and stop them. No, that's not the way. That's definitely not going to get you the results you want. If you want some sort of remuneration, justification, vindication, justice, if that's a word I can use when referring to family court, you're probably going to want to tailor it or package your claim in a way that the judge is inclined to make a ruling on with respect to a claim you're making. Let me give you some examples. Financial abuse and spousal support. How are you going to make a case for spousal support in a scenario or situation where the other party is or was the financial manipulator? Well, yet it's not like going into court waving the red flag, just saying, hey, there's been this abuse. Now you're saying, hey, I need for you, the court, to issue, let's start with a temporary order for support, financial support from this spouse, this other party, because if you don't, they're going to continue to control the money, use the money as a tool, weaponize the money, and I'm going to be unable to maintain the status quo to some degree. I'm going to be unable to provide a roof over my head, on our children's head. I'm going to be unable to eat, to basically live, to sustain if you don't. It's not that you're asking the court to punish them for being the financial manipulator or control freak. You're asking the judge to take that into account as you're making a claim for alimony or spousal support. You see the difference? How about when you're asking for exclusive occupancy of the marital home when there's young children involved? You're making a claim for that. Again, temporary, let's talk temporary exclusive occupancy for now. You're going to say to the judge, hey, I need exclusive occupancy of the home, because if not, I'm not going to be able to find somewhere to live that's going to be familiar to our children, not have to uproot them, and affordable, particularly because the rental or to purchase a home prices and rates are ridiculous. So if I am able to stay in the marital home and you, Your Honor, orders it, and you take into account that the other party, my spouse, has been financially controlling and manipulative, the order for me to stay in the home will reduce the reliance on me having to figure out a way to maintain stability, a roof over our children's heads, familiarity for the children because they're so young, and rely on the other party to help do that. Staying in the marital home in a situation, of course, with exclusive possession, not with the financial abuser in the home. And yes, that does make a difference. That makes a huge difference. And that's another topic for another episode. It's going to be really, really difficult to be able to do that, particularly because the other party / spouse has been manipulative and weaponized the money and the assets, etc., especially in scenarios where they've cut you off completely to access to anything. If you maintain exclusive occupancy of the marital home, that sort of negates the need to have to deal with the other party continuing to block you or to limit your access or to deny you. How about with respect to child support? Well, child support, it doesn't really factor in as much unless your claim for child support is going to be based on an income that surpasses the guidelines for your specific state. So if you're in New York, for example, where I believe the cutoff is $165,000 or something like that, and your spouse / other party happens to make $175,000 or $200,000 in income, then their past behaviors and their antics now are definitely something you want to bring up to the court with respect to the judge deviating from the calculations that are set forth in the child support statute. What does that mean, Tracey? What does that mean? That means if you're in New York and you have one child, the 17% of the combined income is what is allocated to child support. So of the combined income total, the 17%, if it is $150,000, then you take 17% of the $150,000 and you apportion it based on the respective incomes. So if it's 150, say it's 150,000, you make 50,000, the other party makes 100,000, 17% of 150,000 is what? Almost 25,000? I don't know. I'm good at math, but that's not the point. 25,000. So of that 150, your 50 is what? Maybe 1/3, and the other parties is 2/3. So of the 25,000, yours would be 1/3 and the other parties would be 2/3. But whoever has custody doesn't actually physically pay that amount. The other party that doesn't have custody pays their amount. So if the person who makes the 1/3 has custody, then the 2/3 is paid by the other party who doesn't have custody. And so that's easy, right? Whether there's financial abuse or not, that's easy. The calculations apply, that's it. But when the cap, every state has a cap. In New York, as I mentioned, the cap is 165. So if the combined income is 175, then what the judge does is they use their discretion there. That's what we call the catch-all phrase, or it's the last factor in the Child Support Standards Act. And so the judge has a little bit more discretion to determine how they're going to come up with that figure that the non-custodial parent is going to pay to the custodial parent. And so if you want the judge to take into consideration the fact that the other party, your spouse, has been financially abusive, and that financial abuse had trickled down to your ability to provide for your children or your child, then you definitely want to bring that up and say, hey, listen, you're not waving a red flag. Hey, I want you to hit them, with the highest number you can come up with because they've been the financial abuser our entire relationship, our entire marriage. No, you're not going to do that. You're going to say, well, judge, if you would take into consideration that my child was, forced to quit all sorts of extracurricular activities that they really, really loved. We were forced to change schools because the other party was very manipulative and started to hide money or deny access to money, so I couldn't pay for school tuition anymore. You're going to do it that way. I hope that makes sense. You're going to do it that way. You're going to tie it into the claim you're actually making, as I mentioned before. And your claim is for an amount of child support that's going to help you provide for your children and maintain as much as you can the status quo. Financial abuse with respect to property division, asset division. Now, that's a huge one because financial abuse and manipulation and control of the other party, of your spouse, is going to matter, particularly in states where the laws for property division are equitable distribution as opposed to community property states. Again, let's take New York, for example, which is an ED state. ED is short for equitable distribution. You're going to make a claim for equitable distribution is when the courts are actually going to do what they think is fair with respect to dividing the property. It's not necessarily 50-50. It can be 50-50, but it may not be 50-50. It could be 60-40, 70-30, in either direction. No spouse is favored. What the court is going to look at is what's fair. They're going to look at past history of spending, of accumulating assets, of wasting or dissipation of the assets, of, to some degree, fault. So if fault is an issue, they can take that into consideration. Future earnings. There's so many different factors that they can consider to determine what they think is fair in an ED state. And so if you want the judge to take into consideration your spouse's past manipulation and control of the finances, you're going to say, hey, listen, even though the other spouse has managed to make and accumulate $500,000 in assets in the last 3 years, they've been really depriving me or us of partaking in the fruits of that labor, and now they're denying me any sort of split of that accumulation of assets. And so I'm asking this court to give me what is fair, what I've been denied, or make an order or ruling that is fair and just based on the fact that I've been deprived of what I help contribute as far as our wealth and our assets are concerned. So you see how that applies. You see how financial abuse, financial manipulation and control is something you want to bring up to the court in the context of the claim you're making, the actual legal claim you're making, not the just, hey, I want this court to punish him or her or to penalize them or to make them suffer just because they've been an abuser, a financial abuser. No, you want to make your argument fit inside of a legal claim, one of those legal claims I just discussed, to ensure that the judge actually does take it into consideration. Now, once your case goes to trial and you want to tell your entire story and give the entire narrative in your way, that's even better. That's when you would actually get some sort of vindication, some sort of remuneration, justice, and some peace that you've been, after you've had to endure the abuse for so long, and particularly during the divorce process, and you seem to have not been able to get the judge or the court to really pay attention to what you have endured. Going to trial and actually telling your story, narrating your story, when you have the judge's full attention, you have the judge as a captive audience, may be the better option for you. So If you are in a situation where you have experienced abuse, financial manipulation, control of your spouse, the other party, and you're at the point where litigation has come up or even negotiations, I don't know if financial abuse is going to have as much power or be as much leverage during negotiations, but it certainly doesn't hurt to try. It's going to be incumbent upon you, though, to work that into a strategy, because the courts don't necessarily take it upon itself to do something because there is signs or are signs of financial abuse. You may want to plot out your position with respect to using history of financial abuse occurring so that you are not left feeling like, a perpetual victim or survivor, either way. So anyway, I hope this was helpful. The workshop is coming up today. So if you have not signed up, sign up for the workshop. It's a free workshop. If you've taken the diagnostic assessment, you are able to sign up today. Hurry up. If there are seats available, you can actually take advantage of one of them. Sign up, join the workshop. We're going to actually address the diagnostic assessment results, and discuss those in detail and let you see what that looks like. The diagnostic is to help you figure out exactly what the issues are, the bottlenecks are in your case, because family court cases have so many layers. You can easily get derailed and distracted by thinking that these 3 key issues are your real issues, your real problems, and they're not. It may be 5 other ones that you've been ignoring that are just becoming more and more expansive and therefore impactful in a negative way. So if you haven't already, go to social media. The workshops is actually all on social media. On my page, The Divorce Solutionist on Facebook, or Pro Se Strategy on Facebook, or on Instagram, or my YouTube channel, or my TikTok. They are the registration and the sign up. If you're not on my email list, you need to get on my email list so that you will know in advance when these workshops come up. But they are free. We will be live. We will be doing it by Zoom, and I will be answering questions. And then you have the opportunity to do an upgrade and be on the hot seat, one-on-one hot seat, to actually discuss what the bottlenecks are in your case based on your diagnostic results. So anyway, the link will also be in the show notes, so you can sign up there. Again, seats are limited. It's Wednesday, March 25th from 6 to 8 p.m. via Zoom, and I look forward to seeing you there. If you can't make it and you want to talk to me about your financial abusive situation and how you should frame it strategically for your case, whether you have a hearing for temporary support coming up, or you have a trial coming up, or you just want to use it to negotiate settlement, please feel free to schedule a strategy session and we can hammer it out there. So in the meantime, thank you so much for tuning in. I'll talk to you soon. Take care.
If you're having an active family court case and something already feels off, you need to identify where your case is seriously exposed. Schedule a strategy session now so we can shield your case from more damage. You can't afford to keep guessing. It's costing you way too much.